Good morning and welcome as we reconvene the 25th meeting of the Joint Select Committee on Human Rights, Equality and Diversity. This public hearing will be broadcast on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I'd like to welcome the officials from the Office of the Prime Minister, the Ministry of Labour and Small Enterprise Development, the Equal Opportunity Commission, the Human Rights Clinic of the Ubud Law School, and the Employers Consultative Association this morning here with us. My name is Nian Gatsvidoli, and I'm the chairman of the Committee on Human Rights, Equality and Diversity, and I'll now introduce the members. I'll allow them to introduce themselves of the committee who are present with us, starting from my right.
Good morning, everyone. Member Saddam Hussein.
Morning, everyone. Senator Hazel Thompson, Ahi, member.
And I'd like to now invite the officials who are present with us to introduce themselves. And we can start from my left with the Permanent Secretary of the Ministry of the Office of the Prime Minister, Gender Development.
Jacqueline Johnson, Permanent Secretary, Office of the Prime Minister.
Stephanie Fingal, Interim CEO of the Employers Consultative Association.
Natalie Willis, Acting Permanent Secretary, Ministry of Labour and Small Enterprise Development.
Good morning, everyone. Haran Ramkaran Singh, Director, Legal, Equal Opportunity Commission.
Good morning, Jason Nathu, Tutor, Ubud Law School.
Good morning, Devanti Miraj Ramdeen, Chief Executive Officer, Equal Opportunity Commission.
Good morning, Sangeeta Bundu, Senior Legal Officer, Ministry of Labour and Small Enterprise Development.
Good morning, Sabina Gomez, Chief Labour Relations Officer.
Good morning, Kevin Williams, Acting Deputy Permanent Secretary, Ministry of Labour, Small Enterprise Development.
Good morning, Keston Nanku, Chairman of the Employers Consultative Association.
Good morning again to you all, and thank you and welcome. This morning, we are here to discuss sexual harassment in the workplace. In 2018, the International Labour Organization highlighted the issue of violence and harassment in the workplace during the 107th session of the International Labour Conference. It is the right of every individual to work in an environment free from harassment, and in this regard, sexual harassment in the workplace can no longer be classified as a personal or interpersonal issue. The above quote may be very familiar to some people as it came from the National Workplace Policy on Sexual Harassment laid in the Parliament by the Honourable Minister of Labour and Small Enterprise Development, Senator the Honourable Jennifer Baptiste Primus, on March 8, 2019. Due to increased dialogue and media articles locally and internationally, acknowledgement of which would have precipitated development of Trinidad and Tobago's first national policy on sexual harassment, as previously referenced, this committee undertook to understand the challenges related to sexual harassment in the workplace, to examine the prevalence of allegations and instances of sexual harassment in the workplace, and to examine and make recommendations on current management procedures and mechanisms to seek redress as a victim of sexual harassment in the workplace, and current legislation and policies, local, regional, and international, to treat with victims of sexual harassment in workplaces in Trinidad and Tobago. We would have received written submissions, quite a number of them, from the Ministry of Labour and Small Enterprise Development, inclusive of the recently laid National Workplace Policy, the Equal Opportunity Commission, the Employers Consultative Association, the Office of the Prime Minister, the Trinidad and Tobago Police Service, the Industrial Court of Trinidad and Tobago, the International Labour Organization, the United Nations, UNICEF, the Faculty of Law at UWI, the Office of the Ombudsman of Trinidad and Tobago, and the CEDAW Committee of Trinidad and Tobago. And let me express sincere gratitude, mine as well as to all members of the committee and the Secretariat, to all the agencies that assisted with the circulation of the online link to the committee's online survey conducted from February 13th to March 11th, 2019, to which we had 571 responses. I would now like to invite brief opening remarks from Mrs. Natalie Willis, Ms. Jacqueline Johnson, Mrs. Devanti Diane Maraj Ramdeen. I think we are having Mr. Haran Ramkaransing instead, yes? Ms. Stephanie Fingal and Mr. Jason Nathu. So we start with Ms. Willis and continue that way.
Thank you, Madam Chairman and members of the committee. We at the Ministry of Labour and Small Enterprise Development are grateful for the opportunity to meet with the Joint Select Committee on Human Rights, Equality and Diversity for this inquiry into sexual harassment in the workplace. Madam Chairman, the Ministry's core functions focuses on the improvement on the quality of life of the citizens of Trinidad and Tobago through, inter alia, setting the standards for working conditions and assisting in the employment of employers and employees. Madam Chair, the work of the Ministry has been given even greater prominence in national development with the adoption of the United Nations Sustainable Development Goals, the SDGs, in 2015, and specifically Goal 8, which speaks to promoting inclusive and sustainable economic growth, employment, and decent work for all. Decent work in this regard refers to the work that is safe, productive, delivers a fair income, and upholds the rights of workers. Additionally, the Government of the Republic of Trinidad and Tobago, as a member state of the International Labour Organization, upholds the edict that labor rights are human rights and is ever committed to respecting all human and labor rights, including fair employment practices, a safe and healthy workplace, and a workplace free from bullying and harassment, including sexual harassment. Sexual harassment is a violation of fundamental human rights and adversely affects the working environment, undermines gender equality at work, creates unfair practices in employment, and negatively impacts the dignity and well-being of workers. Moreover, it has significant damaging effects on the victim, alleged perpetrator, their homes, organizations, and communities. The right to work in an environment free from harassment is breached when anyone is subjected to sexual violence, harassment in the workplace. In closing, Madam Chair, I wish to emphasize that the Ministry of Labour and Small Enterprise Development is committed to the implementation of the National Workplace Policy on Sexual Harassment in Trinidad and Tobago, which is designed to prevent, prohibit, and address sexual harassment at all levels in the workplace. The long-term goal of the policy is to eliminate any and all incidents of sexual harassment in the workplace. The Ministry, therefore, is committed to achieving this goal and is grateful for the opportunity to contribute in any way to this inquiry into sexual harassment in the workplace. We at the Ministry look forward to fruitful deliberations and any suggestions as we seek to implement this policy. I thank you.
Thank you. Ms. Johnson.
Good morning, Madam Chair. The National Workplace Policy on Sexual Harassment is one of the major measures we identified in the National Gender Policy for Development. So we are happy to be part of this process, which will finalize a document that will support our achievement of gender equality by 2030. Thank you.
Thank you. Mr. Ramkaransing.
Yes, Madam Chair, members of the committee, on behalf of our chairman, Mrs. Lina Seabrand-Sweet, I thank you for including us in this deliberation, and I apologize for her inability to be here this morning. Madam Chair and members of the committee, sexual harassment is an expression of sexual violence. It is a form of discrimination based on sex, and it is a violation of human rights. It has been acknowledged as a serious problem in the workplace. Based on complaints that have been lodged with the Equal Opportunity Commission and our investigation into these complaints, we have seen where incidents of sexual harassment have undermined working relationships and have contributed to sickness, absenteeism, and stress generally. When employers do not adequately address the allegations that employees have made, and the employee is now forced to lodge a complaint with the Commission, and we are forced to intervene and investigate, the employer now has to devote a lot of time, a lot of resources into treating with the complaint, and they face the risk of incurring significant legal costs should the matter be referred to the Equal Opportunity Tribunal, which is a court for hearing and adjudication. The Commission's core mandate is to work towards the elimination of discrimination and promote equality of opportunity among persons generally in Trinidad and Tobago. Sexual harassment is a barrier to achieving this goal. At the same time, sexual harassment is a form of discrimination based on sex, and it is therefore one of the areas which the Equal Opportunity Commission is empowered under the Equal Opportunity Act to treat with. Our function under the Equal Opportunity Act is to receive and investigate complaints and, where possible, conciliate the matter. So our function is not just limited to conciliation, but we have the power to compel a respondent to provide information in response to an investigation. We can compel them to come to us, to provide documents, transcripts, videotapes, any form of evidence that we can get. And if a respondent does not do so, we have the power to prosecute them in the magistrate's court for noncompliance. Based on the investigation, we can refer the matter to conciliation. If the matter is not resolved at conciliation, the Act creates a second institution, the Equal Opportunity Tribunal, which is a superior court, and the matter can go there for hearing and adjudication by a judge who enjoys the same status as a judge of the High Court. And it is to be mentioned, ma'am, that under the Equal Opportunity Act, complaints can be made by any form of employee, so that we're not limited to questions as to whether this person is a worker or not, whether they're a domestic worker, whether they are senior management, academic staff. Any form of employee, including independent contractors, can make a complaint to the Commission of Sexual Harassment. In our responses to the in our written responses to the questions asked, we have said there are 3 matters before the tribunal. In actuality, there are 4 matters.
We were going a little more into depth as we asked the question.
And I just want to mention an interesting fact. It may be interesting to note. Out of the 4 matters, 2 of the 4 were complaints lodged by men saying that they were sexually harassed by women who were senior to them in management, so that it is an interesting dynamic. We tend to think sexual harassment only being a man harassing a woman, but, you know.
Certainly, and I'm sure as we go into discussion today, we'll have a little more interesting revelations to come in there. So thanks a lot, Mr. Karan Singh. Can I invite Ms. Fingal now to...
Good morning, Madam Chairman. And the Employers Consultative Association is pleased to be invited to participate in this inquiry today, as in contributing to the formalization of national policy and legislation on sexual harassment in Trinidad and Tobago. The ECA, Employers Consultative Association, is a non-profit organization. At current, we have approximately 525 active members throughout all industry sectors in Trinidad and Tobago. Our objective is to promote a productive economy by providing employers with guidance and services for the proper management of employee-related issues, promoting adherence to legislation, good industrial relations practices, and the principles of natural justice. We provide these services at the national level and at membership engagements through in-house and external programs. All employees in Trinidad and Tobago are invited to participate in our national programs. The treatment of sexual harassment matters is given due regard in this process, and we do this through sensitization sessions, free at times, consultancies with independent employers, training programs, assisting management with disciplinary matters, and giving general support to any initiatives of the EOC, the Ministry of Labor, etc., in our advocacy role. Thank you very much.
Thank you, and Mr. Nathu.
Good morning again, Madam Chairman and members of the committee, and thank you for inviting the Ubud Law School's Human Rights Law Clinic to participate in this exercise, and also for recognizing the work of the students of the clinic. From the onset, I must apologize that we were not able to answer the questions that you've asked of us this morning, and I wanted to explain how the clinic functions so that you would get a sense as to what our difficulties were in answering those questions. The Human Rights Law Clinic is a program that's designed to afford our students practical experience through public education and advocacy. It runs for 10 weeks in every academic year. So from early October to early December, our students, among other things, have to choose a project in which they plan to break down complex areas of the law. And one group of our 4 students, well, we had 16 students this year, 4 of them chose the issue of sexual harassment in the workplace, being a topical issue as it is, and getting the deserving of the recognition that it does, to break down any existing law and policy in Trinidad and Tobago at present. Certainly our students are not subject matter experts, so they sought the assistance of an NGO, Women Working for Social Progress, and they would have used their research tools as attorneys to break down and distill what is in our existing policy, the Equal Opportunity Guidelines and the draft policy from the Ministry of Labour. So it is for that reason we were not able to specifically identify the questions that you would have asked. However, I am here to provide any assistance that I can to the committee this morning.
Certainly, and we appreciate the explanation, and we thank you all for being here with us as we approach this most important topic. So we will commence the questioning section at this time. I want to remind everyone to route your questions through the chair as we begin. I want to start us off by defining sexual harassment. And let me just indicate that we would have had all the submissions coming in. And in today's hearing, I want us to be able to, for the benefit of the public who will listen and see this, I want to be able to elucidate some of the things that we'd have gotten in the written submissions for the benefit of the public. So I may ask some questions that you would have submitted information on, but it's simply for the benefit of those who are looking in, because there is a lot of misinformation and a lot of very strange points of view on some of the issues that we tend to consider straightforward based on our immersion in the subject, and therefore I will ask some questions to just open up some of these things. So my first question, I'm going to ask it directly to the Ministry of Labour, the Permanent Secretary, for her to define, for the benefit of the public, sexual harassment, and then I'll ask a question further to that.
Thank you, Madam Chair. According with the National Workplace Policy on Sexual Harassment in Trinidad and Tobago, sexual harassment is defined as any physical, verbal, or non-verbal conduct of a sexual nature and other conduct affecting the dignity of women and men, which is unwelcome, unreasonable, and offensive to the recipient, and a person's rejection of or submission to such conduct is used to explicitly or implicitly as a basis for a decision which affects that person's job or under hostile work environment, conduct that creates an intimidating, hostile, or humiliating working environment for the recipient. So it mirrors 2 aspects.
Now, in our culture, there are, how can I say it? We tend to be complimentary. I'll just use it that way, all right? Is any kind of compliment a sexual harassment case? How do you distinguish between a compliment and something that is sexual harassment?
Firstly, for it to be defined as sexual harassment, it must be unwelcome by the recipient. If it is, and the policy speaks to the awareness of our social construct in Trinidad and Tobago, and that we, in some instances, it may be throwing pecong, but if it is that the conduct or behavior makes that person uncomfortable, or that person deems it as unreasonable or unwelcome, then it is defined as sexual harassment. If I may ask my Chief Labor Relations Officer to go further.
Certainly.
Right. What makes it sexual harassment would be the sexual content or the innuendo in it. Because sometimes if you give somebody a compliment, that isn't sexual harassment. If you tell them, you know, you're looking really nice today, and you accept the compliment, that's not sexual harassment. Or, you know, normally we would throw pecan at one another, and, you know, but once the joke is of a sexual nature and the person finds it, or the person becomes uncomfortable with it, and what we advise is that there are different, how should I say, levels of seriousness. So if you find it uncomfortable, the direct approach, you just approach a person and say, I didn't like what you said, it made me uncomfortable. And if the person apologizes, then we suggest that, you know, things could be left at the level of an apology. Not everything has to go towards litigation based on the seriousness of the comment or whatever it is. Some could be slight, some could be simple, that an apology, you directly approach a person and indicate to them that you found what they said offensive and not conducive to a working environment, or if it was objectionable, or you didn't really receive it in terms of how they were putting it across.
And the last question I'll ask on this kind of definitions issue is sexual harassment always directed from male to female?
No, sexual harassment can be via male to male, male to female, female to male, or female to female. And the conciliation unit to which Ms. Gomez is attached would have received instances or persons would have approached them for advice. And in 2 instances, one was male to male and one was female to male.
So the public should now be clear on what sexual harassment, what constitutes sexual harassment, the fact that sexual harassment can be either way, any way regarding the sexes, whether it's male to female, female to female, female to male, male to male. Anyone can then undergo sexual harassment. Any worker in the workplace. Okay. So having defined that, one of our issues is to understand the challenges related to sexual harassment in the workplace. Based on the submissions we would have received from all of the groups represented here, we saw different issues coming up. There's the issue of underreporting, because in every submission, I don't think we crossed in any one year maybe 4 or as much as 8 reports of sexual harassment coming out. There's the issue of lack of legislation. There's the issue of difficulty of investigating allegations. There's the issue of lack of awareness of what constitutes sexual harassment. Some people, perpetrators, may not understand, and victims, similarly, may not understand exactly what is happening. They may feel the discomfort, but not understanding that there's a name for this type of behavior. And then there's the issue of the paucity of sexual harassment policies in the workplace, where there's no uniform, or I should say there was, at the time of conceptualization of this inquiry, that national policy had not yet been laid. And so different issues would have come to the fore from the different written submissions representing challenges related to sexual harassment in the workplace. And everyone would have identified, based on the questioning, the results of sexual harassment and what the results on the victim, the results on the workplace itself, and the impact it has on productivity in the workplace and the work environment. So what I wanted to ask, and the question can be thrown out to Ms. Fingal from the Employers Consultative Association, Ministry of Labor, the Legal Services, Mr. Ram Karan from the Equal Opportunity Commission, as well as, I don't know if the Human Rights Clinic would want to weigh in on it. What is the main challenge or are they all conflated into one huge challenge? Or if we had to identify one or two, what are the main challenges, based on all that we have spoken about, that would constitute that barrier to reducing sexual harassment in the workplace? And anyone can start first. What's the most pressing challenge? Ms. Finger?
What we have discovered is the fear of losing a job by the victim. And particularly when you have persons working in owner-managed businesses. And in other companies, larger companies, there might be some process or some recourse. But you find, particularly with the smaller businesses, medium-sized and so, employees, for one thing, they're ignorant, as you just mentioned, Madam Chairman, that they might be unaware that it is, in fact, sexual harassment. And, of course, they feel intimidated, perhaps sometimes threatened, and embarrassed. There is still this very strong feeling of being ashamed of having to report such a thing. And then where employment is the key issue, retaining that employment, you'll find a reluctance as well. Just recently, I handled giving some advice to someone, and the victim felt very sorry for the perpetrator. She was actually crying after making the report and wanted to discontinue the report. So you find there are several reasons, and depends as well whether the employer and the organization really treat those things as Trinidadians and Tobagonians as significant issues of a grievance, or to be addressed through disciplinary processes and so. So there are a myriad number of reasons why we might have underreporting and also having matters not addressed. Putting a policy in place then behoves that company to adhere to that policy. And you find it's a very sensitive topic, and how they go about introducing it when there might be perpetrators known to different persons and ruling it out and insisting on an adherence. So many different issues play at this point in time. Thank you.
Anyone else wants to weigh in on this?
Hi, Madam Chair. Just to bring it back again, I wanted to come back to the mandate of the clinic. And I think that one of the major problems in this country is a lack of awareness of rights generally. And it is for this reason the law school has used the students to do that sort of public awareness. I believe that this is not an issue that only touches on sexual harassment, but people generally do not know what their rights are. So I'm happy that now that there is a policy laid in Parliament, that there would be some sort of public education campaign to the average person, because one of the difficulties that I think is generally faced is that people see parliamentarians speaking, people see documents, voluminous documents, but it is not laid out in an understandable and digestible format for the average person. And I think there's much more work to be done in terms of that, regardless of the fact that there have been agencies such as the Ministry of Labour and the Equal Opportunity Commission that have already done a lot of work in this area.
Thank you. Anybody else wants to give a perspective?
Madam Chairman, I agree with Ms. Fingal and the gentleman from the Human Rights Clinic. Both of what they say lends some credence. That is why with the policy, in terms of rolling out the policy, public education and sensitization to the general public and even to the schools, it's really critical, because even with normal rights issues, like, do I know my rights if I'm dismissed, what do I do? Even with information that will go out through the normal media, you find persons are still unaware that they have rights and know what they are. So we have to go through other methods than the normal methods in terms of reaching the general citizenry. And that has to, and our culture change has to come about in terms of how, being knowledgeable of your rights. So we are looking at different avenues in terms of social media initiatives to bring, to change the conversation or to bring new, especially the millennials, because we looked at the CSO report where they said the majority of working women fall between the ages of 30 to 39. And when you, and even around the 18 to 20-something year old, in the workplace, we have had a situation where the person came in, and what they said to us is that persons, they discussed it with their peers, and they told them to keep quiet, don't say anything about it. And it's an older person who brought them to the ministry for them to say, well, okay, this is what is taking place with me on the workplace. So you find that general fear, and even among younger people, you know, saying to themselves, you know, keep quiet about it, you know, just don't say anything. If you value your job, just don't say anything. So we're looking to capture or to bring that information to persons within a particular age group so that they will feel empowered in the workplace, and to also speak up when they see something is not going right. And even if the person is not empowered to speak up, what about the other persons in the organization who will be silently observing what is taking place? So we touch on all of that. How would a third party observing what is taking place, how could that person intervene to really bring that to the fore? And because if you're not empowered and you're afraid to speak up and you confide in somebody that, or somebody actually see it taking place, then the onus is on that person, you know, to go either approach a person directly and tell them, well, look, what you're doing is not right. Or if that doesn't work, then, you know, encourage, speak to a senior person in the organization so that could be addressed.
Now, with regards to the very low level of reporting of sexual harassment incidents, with regards to our culture of throwing peacock, being complimentary, that kind of thing, are we creating a problem that does not exist? There may be a view that we don't have a sexual harassment problem. How many cases have come forward? Very few over the years. I think if we go from 2013 to 18, I don't even think we crossed 30. How do we know, or why do we think that we have a sexual harassment problem in Trinidad and Tobago? Anyone?
Chair? Well, we can only speak from our perspectives in terms of the cases we have had. Now, sometimes when we only started recording, like we went back as far as 2008, but even the figures that we put in the document, we know it's not accurate because the disputes don't come as a sexual harassment case. They may come as a constructive dismissal. The first case in the court that went to the court was the Republic Bank. That judgment was, we spoke about it in the judgment, in the document. But the cases so we would not pick it up as a sexual harassment matter because they come disguised as other things. Sometimes both parties would appear and not speak about it. Probably in separate talks, they may tell you, well, what would have transpired, so you would know that it's a sexual harassment matter. But that is where the underreporting comes in and us not being able to pick it up over the years.
What has indicated to us that there is underreporting?
If I may, Madam Chair, to answer your first question, what we find happening is when you look at the demographics in organizations, you will find the majority of the employed population comprising females, women comprising, say. And the other thing that we ought to keep in mind is where we have come from, you know, the master-servant kind of relationship, and it continues. So we believe that it's okay when it's not okay. I mean, in the homes, you know, where you have that lack of respect and discipline for the females in the homes, you know, and that translates into the kind of behaviors. So from my perspective, we do have a serious problem, but again, it's now beginning to emerge because of the demographic of having more females comprising the world of work.
I guess what I'm asking, and Mr. Ramkaran, I'll come to you. I guess what I'm asking is, are we just discussing anecdotal evidence? Are there some studies that would have indicated? So for example, when we put this proposal out, we would have put out the survey, an online survey. And the response to that would have indicated that there were a lot of people who felt that they had been sexually harassed, did not report it for certain reasons. But that's just what we did here in preparation for today. So I guess what I'm asking is, if there's underreporting, what has convinced us that there is a high level of sexual harassment which may be taking place but being underreported? Where is the wealth of information residing? Have there been some studies, some surveys, that kind of thing that would have indicated the problem is real and needs to be addressed, but it is not reported, and that putting a national policy into the landscape will allow persons to now come to the fore as there is something that they can hold on to which describes what they have been going through? Are there any studies, any information? How have we been able to at least know informally that there is a problem? That's basically what I'm asking.
Well, ma'am, in 2017, the IDB published a National Women's Health Survey. According to the statistics from that survey, they reported that the prevalence of non-partner sexual harassment was 13%. I don't know how they arrived at the data, but this is the data that they published. They said that the highest prevalence of this type of harassment was in the form of electronic messages with sexual content, which they said occurred at 8%. I mean, grouped in a public space, which occurred at 7%. So those are the statistics from the Women's Health Survey. What I can also say anecdotally from the Commission's investigations, we have not seen it as being a widespread and prevalent issue, but we have seen that when it does occur, it has been a very problematic issue. So it may not be that the entire organization is mired in sexual harassment, but when it does happen, it has the potential to, it has very far-reaching consequences. One example that came to mind, one of the cases that is before the tribunal, occurred where a lady claimed, a female employee at a casino claimed that she was sexually harassed by her manager. And when she reported it to HR, they did not seem to have an idea as to how to treat with the matter. So they treated with it very chaotically, where they actually called the lady and the manager into a joint meeting and told the manager, well, look, this lady said so-and-so about you, what do you have to say? So it seems to me that they had no clue how to investigate this sort of matter. Because it is one thing to say we have a policy where we do not condone sexual harassment, but if you don't have the nitty-gritties to say, well, when a complaint is lodged, how is it to be treated with? Because ideally, when a complaint is lodged with management, because management is your first line of recourse. You shouldn't really have to go to an external agency like the Equal Opportunity Commission. You should be able to it should be dealt with internally within the company first and foremost. But if the company doesn't have a proper mechanism or procedure to deal with it, then that is where it can spiral out of control. And that is where I think it's one thing to say we have a policy that condones sexual harassment. All employers will say that openly, that we condemn we condemn sexual harassment. All employers will say that we condemn sexual harassment, but they don't really know how to treat with it. How is a person to lodge a complaint? Are they what support mechanisms exist when a person lodges a complaint?
Fully understood. So is anybody aware, or has any of the agencies done any type of study, survey that would indicate that the magnitude of the underreporting? No? Okay. So maybe that's an area that should be looked into, because it's important to understand the depth of the problem, and there may be interesting things coming out in terms of the public versus the private sector. Ms. Fingal, you mentioned small companies versus large organizations where the procedures might be more clearly elucidated, might be, sometimes they may not have been. So that kind of data, I think, would be very important as we look at the width and the depth of the problem, and also as the policy gets rolled out. And we'll ask a bit more about that as you come down. I'm sure members will be waiting to ask about that, how we measure the success of the implementation of the policy. So I'll take Ms. Johnson and then members.
Yeah, I don't think we are underestimating the extent of this problem. As Deputy Permanent Secretary and Permanent Secretary over the past 7 years, I have dealt with 6 cases of sexual harassment. In my view, 1 is too much, yeah? And 1 violates someone's rights to decent employment, yeah? So while I agree that there is underreporting and the public sector is quite different to the private sector, the issue of victimization and the cultural nuances and the absence of a policy and people not understanding their rights are critical reasons why things go unreporting. We have plenty employee handbooks, for example, and the issue of sexual harassment isn't written into those books, clearly because of the absence of policy and supporting legislation. Thank you.
Agreed. Senator Hossain.
Thank you very much, Madam Chair. Now, I've been listening to the conversation so far, and a few issues jumped out in my mind, and one will be, looking at it from a realistic perspective, is that currently we have a downturn in the economy. Persons are struggling to get a job or even keep a job, and you have persons who are being harassed sexually at the workplace, and a person may actually feel that if I report my boss to the EOC, for example, how am I going to be protected from being victimized? If my friend saw that I was being harassed, how is this person, who is my witness, who is going to provide the evidence to ensure that I have some justice, be protected? So the question centers in terms of what can we include in our recommendations to protect these victims of sexual harassment from victimization, and also witnesses who will serve to give very good evidence for those sexual predators to be brought to justice.
Speaking only from the point of view of the Equal Opportunity Commission, the Equal Opportunity Act also protects against victimization. So that if you lodge a complaint, and the definition is fairly wide, if you lodge a complaint and based on that you are victimized, you can lodge a second complaint, and additionally witnesses can lodge a complaint. But the reality is that you will be lodging a complaint after the fact. So that if I lodge let's say somebody lodges a complaint of sexual harassment and they are then terminated, while they can lodge a second complaint of victimization, the reality is that would be a complaint after the fact. And to take your point, they would be out of a job. And maybe about a year or 2 down the road, because we are fairly quick about it, a year or 2 down the road, they might get justice in the Equal Opportunity Tribunal, but for that year or 2, they would have been out of a job.
And let me ask, because you will be out of that job for that 2-year period, is there some sort of compensation this person would be entitled to for that period?
Well, yes, because the tribunal is empowered to give damages just as the High Court or the Industrial Court, so that they can get damages and compensation, pecuniary losses, all of these sort of things.
You see, the issue I'm having also is that there will be situations, especially, it may be more prevalent in the private sector, where you will have matters like these coming before tribunals and commissions, and persons may want to settle because they are able to settle because, 1, I get to keep my job, and 2, I may be entitled to some sum of money. But at the end of the day, you still have these sexual predators in the workplace continuing to harass males or females. And that is one of the root issues I think we have to determine. How are we going to treat with that problem?
I understand what you're saying, but from a theoretical point of view, we cannot force an employer, because while the tribunal, any court can say, well, we will compensate the victim. No court can order an employer to say, well, we're going to fire Mr. X, whether it's Mr. Bill O'Reilly or whoever it is. So in the case of Fox News or all those big cases we saw in the United States, a lot of these persons who, the guy from Miramax, I forgot his name, Mr. Weinstein, they continued and continued and continued because they were protected by their organizations. And no court can order Fox to say, we order Fox News to fire Bill O'Reilly, we order Miramax to fire Mr. Weinstein. It was really public pressure that led to their dismissals. You know, when all of these things came to the public front, we saw that with Matt Lauer and all of these famous people in the United States who were dismissed or fired because of sexual harassment. Perpetrators, sorry. It only happened when there was public pressure placed on them by the widespread public, so that the share prices, it really came down to, at the end of the day, it's really capitalism. The share prices or the worth of the company would have been threatened by keeping on these persons, and therefore the employers were forced to terminate them. But beyond that, there's no court can order that you fire the person.
You see, the thing is, because I asked a question because most employers would want to settle simply because of protecting the reputation of their companies. And while somebody's rights are being violated, and that is one of the difficult things about this entire subject matter.
I think Ms. Fingal wants to come in on the discussion.
I would like to suggest that some mandatory referral to counseling or some type of treatment be included in whatever we are doing, either through the legislation or the policy. Because Mr. Nanku mentioned the master-servant history. And we also have a lot of persons who have psychiatric or some sort of medical, something might be wrong with that person, and it's not necessarily, just a bad individual. And we do have to treat sexual harassment. We talk about it as violence in the workplace. We have to treat it with some medical, psychiatric, psychological treatment as well. So it's not just a person decides to harass this person. What is really causing that? Is there a problem with this person? Because if somebody were a bully in the workplace, simply just being rough and gruff, we would send them to the EAP. We would say you need anger management. So likewise, we do probably have to do some more in-depth analysis as to why is this person sexually harassing this individual. Some people do not fire or terminate the services of the harasser because he might be a key contributor to the organization. But the employer still has the responsibility to maintain a safe and harassment-free environment. So if that case were to come up, he would have to dismiss this person. If not, he will continue to have an environment that is not the proper environment for all his employees. And he will continue to have other employees feeling uncomfortable, which is not allowed under industrial relations. So there is that imperative that the employer must make a decision, but it means that person goes to another job. And depending on if he resigns and a call comes, you have nothing to say. So there's no transfer of information that, hey, you are hiring a sexual harasser. And we actually have dealt with a case like that. The person went to another job and went to another job and returned to an old job. And therefore you find that those sorts of cases, those things happen. It mightn't be every day. But what is happening to that individual? Is he naturally wicked, or is there something wrong with that person? His history, and now we do industrial relations and human resources looking at the psychological aspect of behaviors and really trying to find out whether this person should be referred for some sort of medical or psychological assistance in some way.
Madam.
Just to let members and chair know, and the persons here, that the policy does speak to treating with that psychosocial aspect of it. So it indicates that the employer should provide that psychosocial support not only to persons who are victims, but also to the alleged perpetrator as well.
I just have two short questions, just for the benefit of the public, because these are things that may actually encourage reporting for those persons who may have been victims. One is with respect to the jurisdiction of the EOC. Most people may think that I might go to the EOC simply because I'm discriminated. I'm discriminated because I'm a man or a woman or because of where I come from, my nationality. What gives the EOC the jurisdiction to determine matters of sexual harassment?
Well, sex is one of the forms of discrimination that the Equal Opportunity Act prohibits. It prohibits 7 forms, sex, race, ethnicity, what have you. And there's international precedent and international case law for saying that sexual harassment is a form of sex-based discrimination. In the same way, discrimination against a pregnant woman is also a form of sex-based discrimination. And the rationale in both cases is that one's sex is an instrumental factor in the discrimination that one has received. So that, for example, using pregnancy, for example, only a woman can suffer discrimination based on pregnancy. A man cannot suffer that. So therefore, a woman, by virtue of being a woman, only a woman can suffer discrimination based on pregnancy. Similarly, sexual harassment, one's sex is a motivating factor to the treatment that one has received. So that if a man is sexually harassing a woman, because she's a woman, she's receiving this treatment that man would not inflict on another man, because as one of the speakers said earlier, what is core, or one of the elements of sexual harassment is the sexual element to it. So that the sexual attention is being placed on this person in part because she's a woman. There might be other factors as well, but the fact is her sex is one of the factors that led to this treatment.
Yes. I want to just interject.
Yes.
Didn't we already say, and you yourself,
yes.
But no, you said about man to woman, woman to man.
Yes, yes.
But didn't we say that sexual harassment extends between the same sexes
Yes.
in any organization? Yes. So is that really discrimination on the basis of her sex?
Well, yes, because if in the case of a same-sex harassment, the person who's receiving the harassment is receiving it because they're a man. And a woman would not have received that harassment because the person making the harassment is interested in the receiver because, among other things, because he's a man. So that that harasser would not harass a woman the same way because the harasser does not have a sexual interest in a woman. So in other words, yes, it is one of the factors that you look at. Yes, to go back to you to some cases. There was a case from the U.S. Supreme Court, Meritus Savings Banks versus Vinson, a 1986 case. There's also a case from the Supreme Court of Canada, 1989, Janssen versus Polity Enterprises. I can provide it in writing. Please. And there's a case from the House of Lords in England, Porcelli versus Strathclyde Regional Council. I can provide you with the citations.
Thank you.
Yes.
Senator, you have one more question? I want to bring in Senator Thompson to just ask a question quickly and you come back.
Thank you, Madam Chair. When you look at the National Workplace Policy on Sexual Harassment in Trinidad and Tobago, at page 14, the definition, if I may go back there, sexual harassment can be directed at men or women, employers, workers, or third parties, can occur in any industry and has occurred or occurs in the private, public, and state sectors. It can occur on a single occasion or be a series of actions. But when you look at the trend of our discussions, here and elsewhere in the media, and when you look elsewhere at the policy, one wonders if at all we take into consideration that an employer can be harassed. When you look at who may be perpetrators of a sexual harassment offense in the workplace in the same policy of the Ministry of Labor, you see that it says that sexual harassment can occur at all levels within the organizational hierarchy structure, such as between a worker and a higher official in the organization, or between workers or by a third party external to the organization, but who has official contact with the organization's personnel. So when you look also at how you should proceed, you're told in the same document that the employer will receive the complaint and then he takes it elsewhere. And so it seems to me that in the literature, in our discourse, we are not looking in that direction at all. And I looked at the law as it then was in the Bahamas, Sexual Offences and Domestic Violence Act, and it spoke about, in terms of the definition, and I would just like to share it. If a person importunes or solicits from a person in a position of authority in any place of employment or in any institution any favor, benefit, or advantage, or the forbearance from the exercise of any right, power, or duty relating to that authority under any holding out or promise of sexual favors, that is also committing an offense. And I'm wondering if there is any way to treat with that, or if we don't imagine that there are, in fact, members of my sex and the other sex who actually set out to entice an employer in a number of ways that he would act in her favor, or in, or a male employer that he would act in her favor and get benefit. And in doing so, it creates an unfair advantage, and it poisons the environment for the rest of the organization. Because we can't always be looking as women as victims. It is true that in the majority of the cases they are. But in fact, there are instances when it works the other way. And if it does, if you agree with me, what is there in the policy to say how one is to treat with that? Is the employer to report to himself? How do you see in the policy that that should be treated, or is it something that I missed?
I clarify, just to be sure that we're on the same page. What you're referring to is an employee that sets out or entices an employer.
So she's sexually harassing him, in a number of ways. I mean, we can imagine, but I don't want to condescend to particulars at this point. We can imagine. So my friend does immediately. Maybe he has suffered that.
So she is in, or I'm saying she and he. I'm not using that example. It may be any other combination. So she is enticing the employer and encouraging.
So she's seeking a promotion, maybe, other benefits, and acting in a particular way. She's holding out promise of sexual favors to him.
And it is unwanted.
It is unwanted. It is, some men really reject women who come behind them in that way.
So she is enticing, it is unwanted. And you are asking, in that circumstance, who does he,
how does
he deal with that?
Yes.
And maybe as we ask that, I can widen that a little bit to include in a small business an employee who is being sexually harassed from the boss, the other way as well. Who does she or he report that to? Because I think that needs to be made clear, and I think Labour may come in there to explain exactly how. So in case of the employer, who does he report to? In the case of an employee who is being harassed by her employer, who is the sole person in the organization, how do they get redress?
Chair, if I may, I think we need to step back a bit in responding to the senator. One aspect of it has to do with your recruitment process, okay?
I don't want to go, I want to answer specifically on that. If you want to take that after, I want to, but I want the answer specifically on this, because it is, to whom does an employer turn? To whom does an employee who is directly impacted by that employer can't complain to the person who's allegedly doing it? How do they get redress?
All right, Madam Chair. Now, the employer, as the employer, he has rights as manager to discipline as he sees fit, because that is a disciplinary matter. And I didn't hear the senator whether she alluded to if there was a false accusation that was made against the employer, or if the incident just happened.
No, she didn't say that, but I want to clarify and to be very clear, because if what you are saying in this circumstance is that they discipline the employee, I want us to think about what the outcome of that could be, and it could very well lead to what you are saying.
Exactly.
So if you are implying then that in a case of sexual harassment of the employer by the employee, they should discipline the employee, how do we deal with that in a circumstance where it is not the terminal employer then? Suppose it was a manager, and you discipline, wouldn't a manager report it to somebody?
Yes, well, we're talking about a hypothetical situation, and as the employer being the top person that you would go to, the final resort, so to speak. But if you're talking about a manager, and the manager has someone to report to, then the manager would, we would recommend that the manager put whatever the claim made against her or him in writing to the person above that person, so there's documentary evidence like, look, this incident happened.
But isn't that employer, if it's the person of last resort, isn't that employer putting himself at risk by disciplining the employee?
Well, if it's the employer, there's also, and the employer is the top person, by not putting himself at risk, there should be an HR. If there's an HR department, then the HR department should deal with guidelines to follow any discipline, because that's as Ms. Fingal shaking her head, and as the employer, maybe she'll want to have an input. But in terms of looking at it, if something happens with a person at a junior level towards a senior person, and this person is being affected, then by all means, there has to be some guidelines or some measures that the person would take place, whether you want to write this person and point out the actions of the person that occurred and whether it's not conducive to the working relationship. So something has to be documented with respect to the actions of the individual towards senior management, because you would have, in terms of any organization, you should have lines of communication on how you ought to communicate. So if there's some impropriety in terms of how the communication is taking place, he still has to follow a procedure in terms of documenting on such and such a day, this occurred, and this behavior is not appropriate for the business environment or is not conducive. So you lay the groundwork and you tell the employer, go through some sort of disciplinary measures, notwithstanding, because the employer should not be afraid to do what is necessary in the workplace.
Well, I think they should be very afraid, because what can transpire from all of that is a counterclaim from an employee. And I am wondering, what is the role of the Ministry of Labor in both cases? If you have a 5-member staff and your employer is harassing you, where do you turn? To whom should that employee turn? And in a similar case, if it's an employer, you are the person of last resort, and somebody is harassing you, and you discipline them, you open yourself up to them saying that you harass them. What is the external agency? What is the role of the Ministry of Labor in assisting both of these cases?
All right. Now, in the latter case, where it's a small organization and it happened, I'll tell you what it transpires now. The worker would come in to us seeking advice. They will either call if we find the situation is serious, we'll tell them to come in. They will come in and say, okay, this is the situation that occurred. We would ensure that they write, and this day such and such occurred. You write to your employer. If they haven't done so before, we don't automatically pick up the phone and contact the employer. We allow, have you written your employer? Have you spoken to your HR department? So we tell them, look, write your employer and let them know what transpired on this day, date, event, time, and place, and let them pick it up first. And we would monitor the situation to see if HR really investigate the matter or what sort of redress they have internally, because most organizations, they will have some sort of guidelines with disciplinary procedure.
So if you're an employee, you are being harassed, you have a small organization, you are afraid, but you need to report, the Ministry of Labor, that's the conciliation, yeah?
Yes.
Is the place you would go to make that kind of report. And in the case of an employer,
Well, in case of the employer, if the employer need advice, some of them, they do call us if they need advice. If they have an employee and things are going right, they'll call us and explain the situation to them and what we will advise them to do. If the worker is acting inappropriately, we will advise them, write to your employee and let your employee know this type of behavior is not acceptable in the workplace. Document everything. Vice versa, the same. It works both ways, because if you don't document that this thing happened, it could escalate and go further.
But do
and
you
then
think it's very important, especially in the case of the employer, that they register with an outside party?
Yes.
That this is happening, so that in the case of a counterclaim, because you know how things go, there is some record that somebody else was informed of what is happening.
And what we recommend in the policy is that, you know, if in the case of its higher management, then bring in an external investigator, somebody external to the organization who has a strong reputation that both the employee and you know, all concerned would consider. So you bring in a third party to the organization and let that person conduct an independent investigation.
And that can be the Ministry of Labor?
No, we do not do investigation. The ECA, the ECA.
Can it be the Equal Opportunity Commission as well?
Particularly, we only investigate complaints. So
okay,
if a complaint
so if there's an issue, the ECA is probably something we can say to employers. The ECA is available to assist in some of these kinds of cases. Ms. Finkel, you wanted to weigh in on
yes,
this?
I just wanted to say, yes, we will assist, we'll guide the employer exactly as Ms. Gomez advised. You must document and, of course, go to the Ministry of Labor and make the complaint the same way as the employee will, so that there is a record. And if the employee, sometimes an employee might refuse to accept the letter that you might write. So you have to mail it, register it, do whatever you need to do to make sure a record is in place and continue to pursue the matter in a very formal manner. Perhaps it will lead to separation, but of course, as you said, Madam Chairman, that could be detrimental for the employer. So a lot of guidance will be required, and third party definitely in treating with such a matter.
I'm looking again at the National Workplace Policy, and on page 22, where there is mention of the Conciliation Unit Advisory Services. And the policy says an informal avenue where a conciliator provides informal advice and mediation services to walk-in clients, workers, and employers for the resolution of such matters. What do you mean when you speak about providing mediation services? What exactly is meant? Sometimes defining your terms brings clarity. Because if you're talking about civil mediation, as we have in Trinidad and Tobago, and you're talking about a situation where a worker claims to be harassed, and you are proposing to conduct civil mediation as opposed to what in Europe is called victim-offender mediation, which has elements of restorative justice, then I really think that I really want to know how do you view this act of sexual harassment that has occurred? Because mediation is used if there is a dispute between parties where each person feels himself or herself entitled to a particular remedy. But when you're thinking in terms of sexual harassment, where a victim is talking about being wronged, then mediation is really not acceptable. And I just hope, and maybe you can provide some clarification, if that is the route that the ministry is taking. Because all of the literature will tell you that when you go the route of mediation in situations like this, then you're really taking a wrong path. So what is really happening at the level of the ministry? Do they understand the difference between mediation and restorative justice processes? What are they doing? Is it a question they're re-victimizing the victim, where you have most likely an unequal situation where the victim, is coming to meet, as happens in a mediation situation, where you have to decide who is going to speak first, who is, and you come to an agreement. Because the processes, when you're dealing with restorative justice, is totally different. You must have the wrongdoer admitting that I have done something wrong before you proceed. So I really would like to know what is happening.
Okay, I think that's directed to the Ministry of Labour with respect to clearing up what the mediation
right. Now,
involves.
When anybody comes into us, it's an alleged claim. Because in our experience, a worker could come in and say anything. And sometimes when the worker comes in, we take detailed notes in terms of what claims they are making. And sometimes when you call the employer on the phone to hear their side of it, they give you a totally different scenario. You go back to the worker because there are gaps, and then you hear the worker start giving more information based on what the employer said. Now, this is generally, we're not talking about sexual harassment. And when a worker comes in and makes a claim, it's an allegation that the worker is making. So we don't want to jump and say that the person is a perpetrator. It's an allegation until an investigation has taken place and it is proven. Now, you spoke about the advisory service that we offer. I mean, this has been going on with the Ministry of Labour and persons who their grandparents may have told them about the Labour Board, where if there's an issue in terms of a rights issue and workers come in every day, employers call us seeking advice on issues. And we reach so far as to have both parties, if both parties are in agreement, it reaches as far as drawing up a settlement that becomes legally, well, not legally binding, it's not legally binding, but parties uphold whatever settlement is derived of. I'm just talking generally about the advisory services. I haven't reached the sexual harassment as yet. But in cases where a worker comes in and makes a claim that, look, this is going on in the workplace, according to the seriousness of the matter, it's not something that you could mediate. And I will speak recently about a matter, a person came in.
All right, sorry, Ms. Gomez, but I want to focus here because
yes, I know, I'm coming into that.
I want to just focus specifically. When the policy mentions on page 22 that the Conciliation Unit Advisory Services offers mediation services to working clients, does that refer specifically to sexual harassment?
No.
Okay, so it's not applicable here.
No, that's just the service that we provide to any rights.
So this seemed to have been a general statement then about the what is offered by the unit.
Yes.
And mediation is not specific to sexual harassment.
We don't do mediation and sexual harassment matters.
Great.
Thank you.
So I know.
Thank you for the clarity.
Minister Hossain wants to weigh in on the discussion at this time.
Thank you very much, Madam Chairman. Madam Chairman, looking at some statistics provided here over a 7-year period, from 2012 to 2018. These are the reports of sexual harassment. 2012, 1, 2013, 0, 2014, 0, 2015, 1, 2016, 4, 2017, 2, and 2018, 5. Madam Chairman, in your opening statement, you said 1 is too many of sexual harassment. Out of these 13 cases, 2 disputes involve men, 1 is male to male, and the other is female to female. Madam Chairman, I came from local government, and a lot of complaints came to me while I was the mayor of San Fernando. I want to know what could be done to encourage more reporting at workplace, because it is alleged that for people to get work, they must take part in certain activities before they get the work, especially in local government, and it happens throughout the 14 corporations. So I would like to know from you all what policy you could put in place so more reporting could be done, so the persons who acting in that way, some fear should be instilled in them so they wouldn't act like that in the future. And it should set an example throughout the country. That's my question, that's my advice and question today.
Who wants to take this question of how do we encourage reporting?
I know within the local government you have daily rated workers, and they fall under the National Union of Government and Federated Workers. So probably what could be envisioned is that all collective agreements, and that's with the Office of the CPO as well, that they include a sexual harassment policy and guidelines in terms of what could be done, and maybe we can do some outreach with the local government agencies. But the union should be able to take a proactive role in that and including that in all collective agreements or any agreements coming out of the local government. And we have met with NUGE recently, or we have dialogue with them, or most of the unions, because when you look at a lot of the unions like banking and OWTU, they have coming into their own in terms of having a sexual harassment policy within the organizations where they have recognized majority status. So probably the union could be encouraged to incorporate that into their collective agreement, and that will become law once it's registered at the industrial court, and thereby provide some sort of weight so that the unions could actually report disputes, because it is in their collective agreement, registered at the industrial court, and it will become law.
So, Madam Chairman, that's the advice that the ministry will give to the unions and to the corporations and so on, local government.
Yeah, local government specifically. And maybe we can meet with the local government agencies and do a workshop with them in terms of guidance, in terms of what they can do, and sort of empower the workers, because it has to start from the top, and with all the CEOs in the local government and the agencies in the local government regions. All right?
The ministry will have my support, full support, and the Ministry of Local Government, full support. Sure. Thank you very much.
Thank you so much. Senator Hussain.
Thank you very much, Madam Chair. This is a question for Mr. Nathu. But before I ask the question, I just want to commend the Ubud Law School Human Rights Clinic and the 4 students, Sarah, Ansar, Cassian, and Rachel, on the excellent work that they have done with respect to the compilation of this book on sexual harassment. However, when I perused the book, there was one issue that the students raised, which were the protection of those domestic workers. For example, those who are maids, housekeepers, gardeners. How are those persons going to be protected? What can we put into policy to protect those persons who work in those types of environments?
Well, I've seen that there has been some mention of the domestic workers in the national policy. I haven't perused it in great detail, but I think we've spoken about those types of remedies already today during the course of the deliberations this morning. Certainly, the Ministry of Labour does have a great role to play, and also there is, of course, the avenue of litigation. Now, litigation is a last resort. You don't want to jump to go to court. But I think with the empowerment of rights, the empowerment of the average person in understanding their rights, attorneys are becoming more trained in dealing with matters like these, being familiar with the Equal Opportunity Commission and the tribunal. I know that some of the matters that would have been reported at the commission earlier on will now reach the tribunal. So we're seeing developments in the litigation and in the jurisprudence. And I'm hoping that that will also play a part as a deterrent, particularly for domestic workers.
Madam Chair, if I may, the policy at page 12 of this policy where we speak of the scope, it covers household assistants as well as apprentices and trainees. So we ensure that everybody is covered in this document.
And I think one thing is education, public education.
Yes.
Yeah.
Having had this policy approved, the ministry is soon to embark on a comprehensive and intensive public awareness campaign that will ensure that we bring the message to everyone. Actually, we have started this week in terms of being on radio and on different media initiatives where we bring the message to everyone.
While I have your ear, Ms. Willis, through you, Madam Chair, of course, for public education, because persons may consider a workplace as just your place of work. Now, while you're at work, you may have a little social gathering, a little Christmas lime, or you may be required to go on a business trip with some associates. Can those instances, if someone is harassed in those environments, can they file a complaint based on they have been sexually harassed?
Oh, yes, the policy do cover those areas where it could be a social event organized by the enterprise, as well as on transit to your work. Yes, it covers those instances.
Madam Chair, in addition, the industrial court ruled on a judgment that happened on a Friday night lime outside of the work environment, so they look at it's a work-related event, so it could be any work-related event.
I'd like to ask Ms. Sangeeta Bundu, who wants to make a contribution.
Thank you very much, Madam Chair. With respect to the issue of domestic workers, we do recognize, in considering this policy, we do recognize the particular context within which domestic employees and workers may find themselves. And one of the things that we aim to do is allow, when we prepare the legislation, is allow for delaying of individual complaints. Currently, if you are to have a trade dispute brought, it must be brought either through a recognized majority union or a union of which the employee the worker is a member in good standing. So akin to the provisions that are currently in the Maternity Protection Act and Retrenchment and Severance Benefits Act that allow for individual complaints, we want to do that here so that we can empower as many persons as possible to activate their rights.
So let me clarify. What you're saying then is that the policy provides for an individual person to make a claim of sexual harassment.
Yeah.
Through which procedures?
So they would not have to go to a union to lay a complaint before the ministry. They can lay a complaint.
So it comes to the ministry?
Yes, and they would not need to get an attorney either. They can come themselves. So they're saved cost in that regard also.
Members and officials, we have simply scratched the surface of what I think we want to elaborate on. Our first objective dealt with challenges of sexual harassment in the workplace, and we identified challenges such as fear of losing the jobs, fear of losing your job as one of the main challenges, and embarrassment. Some victims have turned around to feel sorry, even for the perpetrators. We identified as well that the lack of awareness of your rights as a worker is also one of the pressing problems, and some workers do not know or understand that what they are going through is not a right thing, and therefore, and maybe some of the perpetrators as well are unaware that they should not be doing this, and so awareness on different levels is very important. We also spoke about the fact that companies do not have proper mechanisms, many of them, even with a sexual harassment policy in place, the mechanism of dealing with the complaint is not clear, and therefore it can frustrate somebody who comes to complain, and when they don't know exactly what's happening and their complaint is not viewed as serious. So the policy is there, so you can say we have a policy, but in terms of the roll down, there is nothing there. We also spoke about the fact that though we are all clear in our minds that there is a problem. There is not enough data to actually suggest you with depth of the problem, because there's a severe case, and I think all of us are saying, of underreporting. But the extent of the underreporting is not fully clear, and if there was some data that could inform that, it would make the problem even clearer to us. We spoke about the fact that persons accused of sexual harassment, even if they are proven to have committed the act, one of the things, no employer can be mandated to fire, and therefore they may be transferred to another department. They may resign from that job, go to another job, without any treatment of the root cause of the problem. And we heard from the Ministry of Labour that the national policy does mention that aspect of treating with the perpetrator, who is maybe a repeat perpetrator, what is happening with that person, how that person is treated, so that they stop the behaviors that they are exhibiting. We spoke about the fact that in some cases, in many cases, it's important to involve a third party in the discussion with respect to what has happened with the incident, so that there is clear records of the behavior, the incidents from another party that may prove very useful in certain cases. If you have an employer, for example, as the one who is being harassed, that may give you some level of outside influence that can look at the problem from a different perspective and assist in ensuring that the process is followed properly within the organization. So we've looked at a lot of issues, but one thing that we have not been able to look at today is our third objective, where we look at the policy and legislation around the region and what the introduction of the policy is really can do. We scratched the surface there when you mentioned now that an individual can make a complaint to the Ministry of Labour, not have an attorney, so it makes it easier now for someone to exercise their right. But there's a lot more I think we need to discuss with respect to the policy, what the policy does, steps that we are taking for the awareness policy as opposed to legislation, and where we have to go and need to go if we want certain outcomes, what can we expect, and where we go, how we go forward. But unfortunately, we need a little more time to discuss that aspect, which I think is critical, because having the policy there is one thing, knowing what to expect, how to use it to our advantage, and therefore, and the difference between policy and legislation, I think those are issues that we need to delve deeper into, and therefore, I would want to ask our officials who are here with us to hold their closing comments, because I think that kind of discussion is very important, and we would want to ask you to come back to meet with us at our next meeting, where we also have some other NGOs coming in to weigh in on this very important topic. I think we'll be shortchanging ourselves and the country, especially at this pivotal time where we have a national policy, if we don't clearly elucidate some more of the issues that will come to bear as we delve into the policy and the legislation and so on issue. So the members of the committee have concurred, and we agree that we will all want to see you back with us. And so the Secretariat will be in touch as we meet again to really strengthen what will come out of this inquiry, which will be the report that we will disseminate to the different ministries and so on involved, so that when we discuss this, it will be a full discussion and a full report as we go forward. So I want to just thank you so much for being here, and I want to tell you that we look forward to seeing you at next month's discussion. April 12th, I think, is our date, so the Secretariat will be in contact, and we look forward to further fleshing these issues out for the benefit of our country. So thank you so much, members of the committee, the officials who were here with us, and I want to, at this time, adjourn today's proceedings.
Okay. Thank you.